Debunking the myth, government ownership of Treaty Crown land and Indigenous sovereignty. The belief that the Canadian government owns Treaty Crown land and has unilateral authority to permit corporate or governmental encroachment is not only historically inaccurate, it is legally false. This myth erases the original spirit and intent of treaty agreements and ignores a body of constitutional and Supreme Court jurisprudence that upholds Indigenous rights and title. In reality, Indigenous peoples are not passive subjects of Canadian law, but sovereign rights holders whose authority is protected under both Canadian constitutional law and international human rights law. Treaties were nation-to-nation agreements, not land surrenders. From the outset, treaties such as Treaty 1 were negotiated as nation-to-nation agreements, not land sales. Oral histories confirm that Indigenous nations understood these treaties as agreements to share the land, not surrender it. According to legal scholar Aimee Craft, 2013, Indigenous signatories to Treaty 1 viewed the agreement as a promise of coexistence, with commitments to mutual respect, land stewardship, and protection of Indigenous ways of life. The written versions, drafted by Crown representatives, often distorted these oral understandings. Crown land, held in trust, not owned outright. In Canadian law, Crown land refers to land held by the Crown on behalf of the public, not as private property. When this land falls under treaties or unextinguished Aboriginal title, the Crown's power is constitutionally limited. In Debunking v. British Columbia, 1997, the Supreme Court ruled that Aboriginal title is a legal interest in the land itself, not just a right to use it. This ruling emphasized that the Crown cannot override Indigenous rights without justification and must recognize Indigenous governance over traditional lands. Similarly, in Silcotin Nation v. British Columbia 2014, the court recognized Aboriginal title over 1,700 square kilometers of land and confirmed that development could not proceed on titled lands without Indigenous consent. When treaties and title are ignored, real-world encroachments. Despite these legal safeguards, both federal and provincial governments, as well as corporations, have repeatedly violated treaty agreements and ignored Indigenous consent. Here are a few key examples. Grassy Narrows, Treaty 3 territory. In Ontario, the government allowed extensive clear-cut logging without the free, prior, and informed consent of the Grassy Narrows First Nation. The Supreme Court of Canada, in Keewatin v. Ontario, 2014, controversially ruled that provinces could take up land under Treaty 3, an interpretation strongly disputed by Indigenous leaders who maintain that such decisions violate the treaty's original intent. Site C Dam, Treaty 8 territory. In British Columbia, construction of the Site C hydroelectric dam has proceeded despite opposition from Treaty 8 First Nations, who argue that the project floods sacred land and violates their treaty rights to hunt, fish, and maintain their way of life. Though courts have acknowledged potential rights infringements, governments have continued construction, highlighting the gap between legal recognition and political will. Coastal GasLink Pipeline, Wet'suwet'en Territory. Despite the Wet'suwet'en hereditary chief's refusal to grant consent, the federal and BC governments approved construction of the Coastal GasLink Pipeline across unceded territory. The RCMP were deployed to remove land defenders, igniting national protests. While elected band councils had signed benefit agreements, the Supreme Court has recognized that hereditary governance holds jurisdiction over traditional lands. Debunking, 1997. These examples reflect a continued colonial pattern. Governments and corporations exploiting land and resources under the false premise of ownership, even when treaties or unceded Indigenous title say otherwise. Legal framework, consent, not control. Even where title has not yet been formally proven, the duty to consult and accommodate applies. In Haida Nation v. British Columbia, 2004, the Supreme Court ruled that the Crown must consult Indigenous peoples when their rights might be affected even before title is proven. This was further reinforced in R v. Sparrow, 1990, which laid out strict conditions under which Aboriginal rights could be infringed, highlighting that such infringements must respect the honor of the Crown and be demonstrably justified. Conclusion. Legal reality versus colonial myth. To claim that Indigenous peoples are merely subject to Canadian government policies and that the Crown owns treaty land is to ignore both historical truth and legal fact. Courts have consistently affirmed that treaties are not extinguishments of Indigenous sovereignty, but contracts of mutual obligation, and that Indigenous peoples hold constitutionally protected rights to land and governance. The Canadian government is not an owner, but a partner bound by law, and any denial of this is a perpetuation of colonial violence dressed as legal authority.